You are watching to your favorite channel, Mr. Ask Me Anything. This is 6th series of Straight to the Questions, 50 most frequently asked MCQs on Civil Procedure Code 1908. It is very important for all India Bar examination and other judicial service examination. If you want to revise or watch the similar MCQs of different law papers, please click the I button or go to the link given in the description below. Before coming to the questions, let us try to understand the brief notes on the CPC 1908. It is a procedural law or adjective law related to the administration of civil proceedings in India. It has two parts. The first part contains 158 sections and the second part contains the first schedules, which has 51 orders, and in it has varied numbers of rules. Coming to question number 1, what is ex parte decree? A decree passed without the presence of the defendant or without defendant's pleader in the court is called ex parte decree. It is provided in Order 9, Rule 6, 1A. Question 2, a court may pass interim order or interlocutory orders. This is to protect the right of the parties till the final disposal of the suit. Here the term interim order means an order given by a court during the pendency of the case. It is generally given by the court to protect the current situation, that is status quo, and to ensure the none of the parties' interests are harmed, while an interlocutory order is a temporary order issued during the course of litigation, that is an order between the commencement and termination of trial. Question 3. Filing a caveat before a court means that the court cannot take a certain action in a suit without notifying the party filing the caveat. Here, caveat in a simple word means to give notice before taking any actions, and in law, caveat is a request made to the court that no order in a suit or proceeding instituted or likely to be instituted before it may be passed without hearing the person filing the caveat. The person who files a caveat is known as caveator, and the person who make an application or expected to make an application to take a legal action or likely to take a legal action on the caveator is called caveatee. Caveat remains in force for 90 days. Question 4. Clerical or arithmetical mistakes in judgment, in decrees or in orders, or errors arising therein from any accidental slip or omission may at any time be corrected by the court, either of its own motion or on the applications of any of the parties. It is provided in section 152 of Civil Procedure Code 1908. Question 5. What is the main objective of the Limitation Act 1963? The main objective of the Litigation Act 1963 is to provide a specific time frame within which a person can file a suit in a court. Question 6. In which circumstances under section 13 subsection E will a judgment of a foreign court not operate as res judicata between the parties? If the foreign judgment is obtained by fraud, it will not be operated as res judicata, because fraud and justice do not exist together. Here, res judicata means a case that has already been decided on its merits cannot be litigated again between the same parties. It is defined in section 11 of Civil Procedure Code 1908. Question 7. What is the main objective of representative suit? The main objective of representative suit is to make easier the decision of questions in which large numbers of persons are interested without using the ordinary procedure. Here, representative suit is a suit filed by one or more person on behalf of themselves and others, or a suit filed by one or more person defending one or more person having same interest in a suit. It is provided in Order 1, Rule 8 of Civil Procedure Code 1908. Coming to question 8. A residing in Delhi beats B in Kolkata. In this situation, where can B sue A? B may sue A either in Delhi or Kolkata. Here, the section applied is section 19 of CPC. which means if the wrong was done to the person or to movable property within the local limits of the jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the local limits of the jurisdictions of another court, the suit may be instituted at the options of the plaintiff in either of the said courts. Question number 9. Foreign court under section 2 subsection 5 of CPC means a court situated outside India and not established or continued by the authority of the central government. Question 10. Judgment under section 2 subsection 9 of CPC means the statement given by the judge of the ground of a decree or order. Question number 11. Principle of res sub judice is provided in section 10 of CPC, which means when a suit is pending before a court of competent jurisdiction, such suit between the same parties under the same title shall not be tried by any court in India. Question 12. Principle of res judicata also applies between co-defendants, between co-plaintiffs. Question 13. Doctrine of res judicata as contained in a section 11 of CPC is based on the maxim nemo dabit bis vagere pro una et idem causa, which means no person can be punished twice for one and same offense. Interes rei publicae ut sit finis litem, which means in the interest of the state there should be an end to a litigation. Res judicata pro veritate accipitur, which means every judicial decision must be accepted as a correct and conclusive truth. Question 14. Validity of a foreign judgment can be challenged in civil courts only under section 13 of Civil Procedure Code. Question 15. Under section 15 of CPC, every suit shall be instituted in the court of the lowest grade. Question 16. In every plaint under section 26 subsection 2 of Civil Procedure Code, facts should be provided by affidavit. Question 17. Limitation Act 1963 is applicable to civil suits only. Question 18. Under which section of CPC option for settlement of dispute is provided outside the court? It is provided under section 89 of Civil Procedure Code 1908. Question 19. Provision of section 80 of CPC says that a notice of 2 months shall be served before filing a suit against the government or any public servant, which is mandatory. Question 20. When is temporary injunction granted? Temporary injunction is granted by court when defendant is about to make some injury to the property of the plaintiff or threaten the plaintiff to dispose the property or creates a third-party interest in the property. It is granted to restrain a defendant from doing such an act. Question 21. Section 34 of the CPC provides payment of interest. Question 22. Section 18 of the CPC provides for place of institutions of suits where local limits of jurisdictions of courts are uncertain. Question 23. Section 20 of CPC doesn't apply to arbitration proceedings but apply to civil proceedings. Question 24. The court under section 89 subsection 1 of CPC can refer the dispute for arbitration or conciliation or lok adalat or mediation. Question 25. The court can enlarge the time under section 148 of CPC for doing any act prescribed or allowed under CPC not exceeding in total 30 days. Question 26. Several persons can be joined as plaintiff in cases where right arises of the same act in favor of such person and where any common questions of law is involved. Question 27. What is NonJointer? Where a person who is a necessary party to the suit has not been joined as a party to the suit is a case of NonJointer. What is decree? Question number 28. What is decree? Decree means a formal expression of an adjudication which, so far as regard the courts expressing it, conclusively determines the right of the parties with regard to all or any of the matters in controversy in the suit and may be either preliminary or final. Question 29. Inherent power of civil court are contained in section 151 of CPC. Question 30. Court fee on a plaint can be permitted to be paid on a subsequent date under section 149 of CPC. Question 31. The provision for substituted service of summons on the defendant has made under Order 5, Rule 20 of CPC. Question 32. Under Order 6, Rule 17 of CPC, an application for an amendment of pleadings can be allowed before the commencement of trial. Question 33. Pleading has been defined under Order 6, Rule 1 and includes plaint and written statement. Question 34. In a written statement, a defendant can claim both set-off and counterclaim. Question 35. A plaint can be rejected under Order 7, Rule 11. Question 36. Order 8, Rule 1 mandates that the defendant shall file the written statement of his defense within 30 days from the date of service of summons. Question 37. Under 7, Rule 11 of CPC, whole of the plaint is to be rejected. Question 38. What must be stated in the pleadings? Facta provenda, which means a material fact, must be stated in a pleadings. Question 39. List of witnesses after settlement of issues must be filed within 15 days. Coming to question 40, a necessary party is one in whose absence no order can be made effectively. Question 41. An ex parte decree can be set aside under Order 9, Rule 13. Question 42. Under Order 9, Rule 6, defendant can be proceeded against ex parte when summon is dully served. Question 43. Provisions regarding filing of suits by an alien under CPC 1908 is dealt under Section 83. Question 44. Suits by indigent person is dealt under Order 33. Question 45. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. Question 46. Which provisions under CPC deals with substituted service of summons upon the defendant? Order 5, Rule 20. Question 47. Imposition of compensatory cost in respect of false or vexatious claims or defenses is dealt under Section 35A of Civil Procedure Code 1908. Question 48. Section 25 empowers the Supreme Court to transfer any suit, appeal or other proceedings from High Court to another High Court or from one civil court in one state to another civil court in any other state. Question 49. What is set off? It means a claim by the defendant against the plaintiff or a plea in defense available to the defendant. Example: A files a suit against B claiming that B has rupees 20,000 due to A. B also claims that A has due of rupees 15,000 to B. Here, when A claims rupees 20,000 to B, then B can set off rupees 15,000 and pay only the balance of rupees 5,000. Question number 50, that is the last question of this video series. A fresh suit on the same cause of action is not barred when rejected under Order 7, Rule 11 of CPC, or dismissed under Order 9, Rule 2, or dismissed under Order 9, Rule 3 of CPC. Okay, dear friends, for this video series I'm signing off. If you have any question or any doubt regarding All India Bar examination, you can put a question or you can ask me through comment below. Thank you for watching Ask Me Anything. Please do like, share and subscribe to support my channel Ask Me Anything. Your one subscribe will give me a new platform of teaching. If already subscribed, then thanks for your subscription. And press the bell icon to get interesting questions and latest updates.